Good evening and welcome to this edition of The Legal Balance. We look at the impact of the law on the mentally ill and the disabled. The National Mental Health Program was introduced in 1982. It was quickly followed by a parliamentary enactment called the Mental Health Act in 1987. Thereafter, Parliament also enacted a law in 1995 to deal with disabled people, and the definition of disability was widened to include mental illness. It's a stark fact that we have about 20 million Indians who are suffering from some kind of psychiatric disorder. How do we sensitize the law to the concerns of these unfortunate individuals, whether it be mentally ill or those who are physically impaired?
In this episode of The Legal Balance, the judgment under review is Upender Bakshi versus Union of India, wherein the Supreme Court addressed the issue of mental illness. Citizens' Right looks at the provisions relating to rights and protection of the mentally ill. And we discuss the issue with Mr. A.K. Ganguly and Dr. Aridhar Sharma.
In the judgment under review, you will get to hear the summary of the decision of the Supreme Court in Dr. Upendra Bakshi's case. Dr. Upendra Bakshi instituted a public interest petition moved by the plight of the inmates of the Agra home.
Upender Bakshi versus Union of India was one of the first cases when the Supreme Court addressed the issue of mental illness. In the context of the conditions prevalent in the Agra mental home, the Supreme Court issued path-breaking directions and guidelines.
The sum and substance of the judgments was a detailed inquiry into the actual ground conditions at the mental homes in Agra, at the procedure as to how mentally destitute persons, especially women, were admitted into such institutions, into a whole host of nitty-gritty details. For example, were they medically checked when they are admitted? How are they treated and kept when they are admitted? How many to a room? What is their diet? What kind of clothes? What is the supervision? What are the benefits and the perks given while they are there? How they are looked after? And so on and so forth. A particular issue which fell for detailed consideration was as to how a large number of these inmates, especially girls, were released, so to say, into the big wide world outside without the superintendent of the mental home ensuring as to where they will go, how they will be provided for, and who will look after them in this strange new world into which they would be released. At the end of it, the court gave a series of very detailed directions which ranged from the building of Pakka roads to reach the mental home, to the amelioration of the infrastructure at the homes, to better buildings, better diet, better facilities, increased budget, and a strict procedural regulatory framework whereby the inmates were medically checked, their ingress and egress, entry and exit was closely monitored. They were actually released only after very close monitoring that they are able to fend for themselves or that they are in the care of people who are genuinely concerned for them and who will not exploit them.
The directions of the court are still relevant for the mentally ill, especially in the light of the recent tragedy at a mental home in Tamil Nadu.
The judgments deal with the whole issue at a very great level of detail and not merely in abstract terms, not merely by words or by slogans and shibboleths. And the care and concern at the grassroots level to change things is apparent and reflected in the judgment. In effect, they lay down a regulatory regime, and I think in today's context they provide a very useful starting point. We have to devise a nitty-gritty regulatory regime now similar to the pattern of the 1983 judgments, but much wider and much more comprehensive, to ensure both at the preventive level and at the punitive level that these incidents do not recur how they can be minimized, and if in the rarest of rare cases they do occur, how very strong, stringent punitive action will be a strong deterrent for future recurrences.
The rights of a citizen, even if he is mentally ill or physically disabled, are clear. He is a citizen and entitled to full constitutional protection. Apart from the full constitutional protection, he is entitled to certain statutory rights.
A mentally retarded or mentally ill person is very much a part of our society and is entitled to the rights that are considered fundamental to all humans. He cannot be discriminated against because of his disability. According to the Mental Health Act of 1987, strict norms are laid down for setting up psychiatric hospitals and empowering the police, the civil society, as well as the judiciary to initiate action when rights of the mentally challenged are violated. The Act enumerates that no person can start a psychiatric hospital without a license. The license would be valid for 5 years and the renewal would depend on the licensing authority's satisfaction with the running of the hospital. Any private citizen can report to a magistrate if he believes that a mentally ill person is being ill-treated or neglected by relatives or other persons. The magistrate is empowered to initiate suo motu action if he comes to know of any ill treatment within his jurisdiction. At least 3 visitors will make a joint inspection of the hospital or the nursing home once a month. The hospital license can be revoked at any time the licensing authority feels that the patients are not being looked after. No mentally ill person is to be subjected to any indignity, whether physical or mental, and no person will be used for research unless such research is of direct benefit to him, either for diagnosis or treatment. If a person feels that he has recovered, he can apply to the magistrate for discharge. The magistrate, after making an inquiry, can order his discharge. The Act imposes penalty or imprisonment for those who violate the provisions. The sterilization of a mentally retarded woman would be a violation of her body without her consent, and as such would be impermissible unless there are other justifications. However, in certain cases, courts of law might grant such consent, keeping the interests of the person in mind. Also, pre-marriage mental retardation provides ground for annulling a marriage. Post-marriage mental illness may, in certain cases, be a ground for divorce.
The issue of mental health and physical disability and the attitude of the law towards this is something which is fraught with numerous issues. We will also have to consider the question of consent of these individuals and how could the consent be empirically determined. In order to examine these issues, we have with us this evening Professor Aridhar Sharma, an eminent psychiatrist and responsible for many blueprints insofar as the mental health policy of the Government of India is concerned. We have Mr. Amul Ganguly, Senior Advocate of the Supreme Court, who apart from his profession has been deeply interested in the field of mental health.
Over 20 million mentally ill persons across the country are subjected to discrimination and inhuman behavior. The recent ghastly incident where 27 chained inmates of a mental home at Ervadi in Tamil Nadu were charred to death in a fire mishap has exposed the ill treatment meted out to this section of the population. This raises the issue of ill treatment and the violation of the rights of the mentally ill persons.
Amulda, in the Ervadi case, you are aware that the Supreme Court has issued notice. They have actually gone to the suo motu, which shows the concern of the court as far as such a case is concerned. But obviously, it's not a few judges, a few lawyers, a few social workers who actually are adequate to deal with this kind of a problem. There needs to be some kind of propulsion, some kind of impetus insofar as disabilities and mental illness is concerned.
Now, this incident has opened up a very important issue. Question is, should the mentally ill persons, whether in a mental home, in a hospital, or any other daycare home, should they be at all confined, kept in a confined condition?
I think one of the most important thing which was not given due consideration, it is not the death of 25 persons, which every day in this country people die, but they died because they were chained. Now that is the more important thing. It is not okay. But in this connection we have to say, this chain is not the first time. Even today you will find in many institutions they are chained and nobody reacts to it. So the most serious thing is the society's reaction to those who are chained, and society permits them to be chained.
It is actually a snowballing process, which is that if society is prepared to alienate a segment of its own because it doesn't have the moral character to cope with it, don't you think that people are going to lose sensitivity
I think, Gopal,
in an increasing manner?
You are right. This chaining incident, this comes generally because people don't want to take the responsibility. See, if you have to take care of the mentally ill person, and if you have to really rehabilitate him into the society, into the community, then you must behave with him as normal as possible. Moment you chain him, he knows you are treating him differently from the rest of the lot. Therefore, you are eliminating him or alienating him from the society.
You are very familiar with the National Mental Health Program of 82, followed by a parliamentary legislation called the Mental Health Act of 1987. Do you really think that the 1987 Act has been successful?
You know, 1987 Act had certain basic clauses, and which one was the change in the nomenclature, which I think was a very progressive one. For example, changing the name of the hospital to psychiatry or mental hospital.
Under the 87 Act, you had to have what is called a mental health authority. Has that authority been constituted? Has it been effective?
You know, I would say that if one has to see very honestly, it is not implemented, because it has to be implemented through the states, because mental health under the constitution is under the concurrent list. Though the center can make the legislation, but the implementation primarily rests with the states.
I think this 1987 Act does not entirely relegate the responsibility to the state governments to constitute authorities. It also obliges the central government to constitute an authority, a mental authority, and in relation to its own areas, central government can constitute a mental authority for the purpose of looking after or overseeing the hospitals, psychiatric nursing homes, or other healthcare units where the mentally ill persons are housed or taken care of in any part of the country. The respective states have their, of course, limited jurisdiction within their territories. They have to maintain those hospitals.
But don't you think, Amolda, in such a case, that the Act could have provided for a council which would ensure the basic minimal psychiatric care which must be in every public hospital?
You are absolutely right, Gopal. This Act is laconic in that measure, on that respect. It does not compel either the central government or the state to set up minimum number of hospitals or the healthcare centers or the units. It doesn't.
And Dr. Sharma, you would recollect that even though this Act was enacted in 1987, a few years down the line, Sheila Base's judgment had to be delivered by the Supreme Court, which was a very important pronouncement that people cannot be kept in jail. But when you look at the incident which happened at Ervadi in Tamil Nadu, don't you think that all these sensitivities which the court has attempted, insofar as mentally ill people are concerned, is like water off a duck's back?
I think you have raised the one very crucial word which I would call how sensitive we are, how caring we are. Now that reflects the attitude of the government, the attitude of the society. This is attitude of those who have what they can do. And as far as this attitude is concerned, I think this is very disgusting and very painful.
Now, to mention the governmental attitude, one important factor you must have noticed. The Act was enacted by the Parliament in 1987.
That's right.
It was brought into force 6 years later in 1993.
The rules were framed only after 5 years. That shows how sensitive the government was.
Right.
But in this thing, I will just say, let us take a very small example of the asylum which you said. Though there was an act not to use the word asylum in 1920, but even today, in this year, in this century, you find the papers, you would find asylum focus. You see the judicial judgments on asylums. Now that shows even the court and media, they have not been able to change the attitude.
It shows the insensitivity.
No, not only insensitivity, how careless or how careful they are.
A police officer could detain a mentally ill person for 24 hours.
Yes. That's what the Act provides.
And if the Act could provide that, don't you think it's an obnoxious provision?
Absolutely, Gopal, particularly when it is silent as to where he should detain. I can understand.
And most of them are to be found in the jail.
That's why it's more important what Dr. Sharma said. It is the mindset of the people, it is the mindset of the people in the society. How do they treat the mentally ill person? How does the family treat the mentally ill person? How do the near and dear ones treat the mentally ill person? These are all cumulative, impact on the, society as such.
There are stipulated laws to ensure that the mentally ill are not ill-treated and that their rights are not violated. But are these laws effective? Under the Disability Act of 1995, a mentally ill and a mentally retarded person is considered disabled if the level of mental illness or retardation is more than 40%. The Act provides ample scope for protection of the rights of these people, including the right against discriminatory treatment.
Dr. Sharma, when we take up this issue of mental health, you're aware that in the law of marriage as well, we have the provision of invalidating a marriage under, say for instance, the Hindu Marriage Act, in case one of the spouses is suffering from a kind of abnormality which was concealed at the time of marriage, or even after marriage there can be a ground for divorce in the event of there being sustained abnormality. Now, in matters relating to dissolution of marriage, in matters relating to even, let us say, the discussion about grounds of cruelty and so on, don't you think that law must interface with therapeutic intervention insofar as dissolution of marriages is concerned?
As far as this is concerned, let me just say not only the mental illness, but till recently like epilepsy, the leprosy, they were the causes where the marriage could be annulled.
Yes.
Now we know that that is not our approach. The approach should be to treat them.
And it is completely curable.
No, these are the treatable conditions.
All curable illnesses must be given a first priority to the treatment, rather than finding a solution the other way. I mean, it is undoubtedly the law must take care of it.
Yes.
But it is socio-legal. It's not just a legal issue.
Don't you think that there must be some kind of a parent's patrial responsibility on the state towards the mentally ill? What happens if, suppose, let us say, a mentally ill girl whom the parents want to get rid of, and she is picked up by the police, she is put in a jail and is actually physically assaulted? Who is going to be concerned about that person? Who is the person who is going to know of the presence of that person in the jail? Absolutely. And is being used? And this is not a figment of imagination.
It's happening every day.
This is something which has been dealt with. Dr. Sharma would recollect in the report as far as Sheila Basis case is concerned, in the implementation in one of the states. You're very well aware.
I think in most of the hospitals, you know, that like some of the young females will be subjected to that kind of a thing.
And don't you think it's a matter of serious concern?
No, but then, you know, like there was a case few years earlier in Pune, in one of the mentally retarded home, and there the superintendent or the director subjected these females for the sterilization.
Yes.
And at that time, actually, I took a very serious thing, that no, that being the society, that is not the response we should have. The response is of the society or the profession or the individuals, that how we can protect those who can't protect themselves.
That is showing disrespect for the human rights
Yeah.
of the mentally ill person. After the UN laid down the principles on which the legislation should be made by all the countries, and that was adopted way back in 1991, well, we took much more time to enact the Disabilities Act of 1995.
But
And that too-
even the 95 Act, Amolda, do you think it contains sufficient enthusiasm
No, it doesn't.
in
Gopal.
terms
It
of
doesn't.
the...
You are right. Except that it is one good thing that that act has done is, insofar as mentally ill persons are concerned, it has recognized that to be a disability. But then, in practical terms, it is very little to give, because even the fund, the national fund that is being sought to be created under the another statute, which came little later in 1999, that's confined only to mentally retarded persons. It
Now-
doesn't apply to mentally ill persons.
In relation to mental health, in reality, Dr. Sharma, how many hospitals are actually there which can cater to 20 million Indians who are suffering from disorders?
I think we have to go, it is not the scarcity of the resources, but it is our attitude. You know, I would just say, any government which is not able to find the resources for welfare measures is not a welfare government. I would say one of the crucial point which is there, the basic element which is there, is the humaneness. Are we humane to the persons? The answer would be no. If we say that whether it's a government, whether it's a society, whether it's an institution, if we, you know, it does not require money to be humane.
Let me again take that example, that horrendous example of Pune. What do you say about any attempt by people to sterilize mentally ill people? How do you think this should be dealt with?
Well,
I think it's a very serious
That's
matter.
a very, very serious matter. In fact, I would go to the extent of saying that of course, if a person is mentally ill, so ill that he can't or she can't give his or her consent for sterilization, because that you can sterilize a person only with his or her
Quite
consent.
correct. Now, how do you elicit the consent of a person who is mentally ill?
Quite right.
And if
And do we have, let us say, sensitized judicial courts which actually can take a decision that the consent ought to be given in a given case?
it is, you know, like when
In
you talk,
England, you're aware, Mr.
yeah.
Dr. Sharma, of intervention by the court in a given situation where the person cannot take the decision himself or herself. But it requires great sensitization.
you know, because today we have moved a step further. We are not talking about a consent, but we are talking about informed consent.
Quite correct.
And
Okay.
informed consent has other elements.
True.
So that means it can't be coerced. You know, that is not only the consent, but if you give some kind of a bribery or something, it is not informed consent. It is also the voluntary. You know, it also that you must provide all the information to the person who is giving the consent.
And then he can take the decision himself.
And then he is right.
No,
you
but
know.
as Gopal says that supposing the person is not in a position, because mental illness are of various kinds. If a person can't take decision by himself, then who is to supply that decision?
No.
Can you go to a court and seek a decision? Are the courts equipped to deal with that situation?
And are the courts sensitized
That's what I'm
to
saying.
deal with
Are they equipped?
these situations?
Because it's not only a legal issue.
Many other countries regarding issue of consent in certain situations, they have developed some system where not only the court but involving the people from the outside and the profession together, and if necessary the family members. So the basic aim is to have the objectivity and not the subjectivity of one individual.
The 1995 Act frequently uses the expression within the limits of economic capacity. And but do you think that is that sufficient affirmative action in favor of this class of people?
No, it doesn't. In fact, Forget about the mentally ill person. Recently there is a judgment of the Delhi High Court which has said that even a person is physically disabled to the extent of 40%, the provision regarding reservation, which confine itself to the employment opportunities of the disabled, doesn't apply to the education sector.
I would just say, one of the paper which I say, it is unethical to have the unfair distribution of the resources.
So there is discrimination.
So if it is a discrimination, it becomes unethical, and I think this is if they are doing unethical thing, anything unethical has to be stopped.
In fact, Dr. Sharma, the United States Supreme Court in Olmsted's case, by a majority opinion of 6-3, took a very, very candid view that insofar as disabled people are concerned, they have to be given resources to support and fortify the assumption that they are capable of being a part of the mainstream of life.
I think that is one of the basic things, because to make them enabled to be part of society, what we have to do, the stress has to be not to see on their disability, but to see their strength and how to make them
how best
enable,
they could live in the community.
So enabling part is one of the most important part. Right.
It appears that we have a long way to go. We need not only more psychiatrists to deal with the situation, but we need to have a different attitude towards those who are physically disabled and even those who are mentally ill. To do that, it is not necessary only to have laws, but you need to inculcate sensitivity of a fairly high order to appreciate the aspirations of all these. There's hardly a mentally ill person who does not want a cure. There's hardly a disabled soul who does not want to overcome his disability and to integrate into the mainstream of life. We must help them. But to do that, we need to give not only the laws a fresh look, but we need to give our attitudes a fresh look too.
If you have any queries or problems, write to us at The Legal Balance, care of NET, PO Box 3136, Lodi Road, New Delhi 110003, or you can fax us at 011-4631-408 or email us at legalbalance@readifmail.com. Next week, we shall be back with another issue of The Legal Balance.